Reminder that the session is being recorded. So if you do have an issue with that, you're welcome to pop off. Otherwise, the recording will be made available on our website and social media, like I said. So an official welcome and good morning to everybody. Thank you so much for joining us this morning. We've got our whole team present, and we've been very fortunate that we're able to invite and share the stage with our colleague Dilen from DTB Attorneys, Detroit Berger. And I'll hand over to Carl to tell you a little bit more about the session, some of our formalities, and then of course a little bit more about our co-host and speaker this morning. Kyle, over to you.
Thanks, Linda. Right, good morning, everyone. I hope that everyone is doing well, and thank you so much for tuning into our webinar this morning. So as Linda said, this webinar is going to be recorded and it will be published on our YouTube channel and website. So please remember to like and subscribe to our channel. And then, yes, as Linda said, if you haven't already, please do sign up to our newsletter. This way you can keep in touch with the TVDM consultants team. I'll also add the link for that in the chat. Then our neighborhood has officially launched, which is very exciting. If you have any questions, then please feel free to send me an email. I'll also add my email below in the chat. And you're more than welcome to take out common property or the managing agent package to explore the platform at no expense if you haven't already joined. And then for those that don't know, we will be attending the NAMA breakfast, which is happening tomorrow morning at Durbanville Golf Club. So if you're able to attend, then please do come and say hi, as we're going to be having a stall there. Then Zelinda will also be speaking on the next Trafalgar webinar happening on the 23rd of March at 5 p.m, where the topic will be amending conduct rules and their enforcement. This is open to everyone, and the link to join is in our neighborhood in the calendar. Please also make sure to check out Charterfin's trustee training, which is in conjunction with TVDM consultants. I'll also post a link for that in the chat below. We hope that everyone enjoys our webinar today. And now I'll hand over to Nicole to tell you a little bit more about Dilen.
Good morning, everybody. Thank you so much for joining us. I am personally very excited today because developers are always very tricky, and understanding how things operate and the handover process between developer and management for the new body corporate is always super tricky. So I'm very excited, but enough about me. So just a little bit about Dilen. Dilen Heerschop heads up the Community Scheme Litigation Department at DTB Attorneys. He specializes in the law pertaining to community schemes and all concomitant compliance issues. He has obtained his master's degree in the state planning law, giving him a keen insight into all financial aspects relating to community schemes. Over to you, Dilen.
Morning, everyone. Thank you, Nicole. Thank you, Zelinda. I think it's always beautiful to be part of these types of trainings. I think later on, when I've made it in life and when I've got the time, I'll also try and run these types of training things, but I think it must be a daunting task. So I think the industry as a whole is very grateful to TVDM consultants for having these types of platforms and having these discussions to try and inform the trustees. So I think, as alluded to in all of the marketing material and what is seen on the screen today, we're going to have a look at the developer and the relationship that the developer has with a community scheme. Before I get on with that, Zelinda told me that we would have to do this training for 3 hours today, just so that we make sure that everyone is well equipped with this. But as I like to swim against the stream, I'll try and rush it off in 15 minutes, or if I really want to make an example or two, it might be 20 minutes and then we're done. But let's see where the conversation takes us. Just before we start off with developers, I just want to speak a bit out of the proverbial judicial bedroom. I'm honored to say that yesterday we were all in Bloemfontein in relation to the Marsh Rose Body Corporate SCA appeal. I'm not sure how many of you have followed this particular matter to where it is now, but this is one of the most important cases, and it relates to the working of Section 15.3b or 15b3 rather of the Sectional Titles Act, or as we as lay people know it, the clearance certificate component. The full bench of the Johannesburg High Court made a decision which would adversely affect the security rights. So in essence, and I don't want to go in too much into the detail of that matter, but simply it sought to prevent and nullify the provision of Section 15b(3) in the sense that security could not necessarily be given upon transfer, and that creates a big pickle in the industry as the body corporates are in dire need of having the security. And I mean, what would the purpose of legislature be to include this type of provision if it was irrelevant or unnecessary, as the full bench seemed to have had the view? So what I can tell you, it was a beautiful environment. I think every time that I go to the SCA, it feels like my first time. You're in awe of the building, you're in awe of what's about to happen, and everything just went great. I think from NAMA's perspective as the intervening party, they did a great job to try and actually inform these justices about what the long-term and what the ranging effects was of this judgment made by the full bench of the High Court. It was definitely a boxing match. I mean, when one goes to the SCA, one doesn't accept a walkover. So it was a great boxing match. We had a full house of justices, 5 justices were there and hearing the matter and now considering what needs to happen. I think all of the parties representing the matter made valid points, gave valid insight into what's going on. And I mean, I don't want to make any preemptions or say what's going to happen, because I might just regret making any of these types of things. But all I can say is one can hope for a very favorable judgment to be given. Regardless of what happens, we are going to have clarity on this point, clarity on the relevance of Section 15b(3). But I do believe that a favorable judgment will be in the bag here, and that we can proceed in a manner where there is now some certainty where there's never been certainty. Personally, I don't think that there's any ambiguity in Section 15b(3), and I don't think there had to be a need to further interpret it by the full bench. But I mean, that's the view that we hold on this side, the view that we hold on behalf of body corporates and in an attempt to protect their security and their finances. So it was a very interesting appeal. We'll keep you updated as and when we get any information, any indication as to when a judgment will be given. And then we'll probably have to have a follow-up where we now discuss how the justices saw the working of Section 15(3)(b). So yeah, that's just something interesting to note. It's a new trend, something that's happening. So yeah, I think it's good to keep track of that. And I think it's important for us to know what the ramifications of this judgment is going to be on our day-to-day management of our schemes. But I think before...
Thank you, Dilen. Sorry to interrupt you there for a second. Thank you so much for you and for Stratafin and NAMA and your brother Rudy for giving so selflessly of your time in that matter. I think it's, when you think it has a massive impact on the body corporate, think times 100. So many times we consult with trustees that say, oh, don't worry, we don't have to worry about collecting those levies because when the owner sells, we're just going to get it back as part of the levy clearance certificate anyway. Or don't worry about them not doing something because we'll just force them to do it at the levy clearance certificate time. And if that had to be taken away, you're basically giving every single person an excuse not to pay their levies. And I don't think a lot of people need more than one excuse not to pay their levies. So it's a massive, massive, massive impact. And thank you so much. And you all looked very dapper in your 3-piece suits. We see the photos on Facebook. I was very jealous when I saw it. I can only imagine the feeling of being in that courtroom yesterday. So really, really well done. And I hope you guys had a good celebratory lunch afterwards. And we're able to download all the information that you had gotten on that day. So very, very well done.
Yeah, well, all I can tell you is when in Rome. So we definitely did have a nice lunch. I think that's part and parcel of the practice, is that you have to celebrate your fight, whether you win or lose at the end. It's worth it to celebrate and to say, you know what, it's been a long time coming and it's now come to fruition. So let's see what's going to happen. But yeah, it's interesting. And just on another comment, I mean, if we have to interpret Marcia Rose as it stands at the moment, together with Zigalala, there is a lot of problems in community schemes. So yeah, it's great that one of these components are now just coming closer to finality, and that we actually have certainty in the industry as to how we should conduct our future issues in this regard. But I think let's abruptly come back to the developer. I I think it's as Linda mentioned and Nicole mentioned, it's something where there's a lot of confusion, where there's a lot of mysticism. I mean, we've got colleagues that have now unfortunately coined the phrase that any time that we say something about sectional title, we need to demystify it. So today I'm going to try and demystify this relationship between a developer, and I'm going to in particular focus on the aspect of when control is handed over from the developer to the body corporate, so that we understand how these arrangements should work, and that we can deal with them in a manner that's in line with all of the sectional title laws that we have. So I think a good start, and I think all of us legal practitioners and consultants would say, oh, no, sectional title law is easy, you should just go and read the act. And I think if one would have to go and try and dot down all of the times that the word developer is used in all of the acts and the regulations and everything, one would get a shock as to how involved and what a critical role player a developer plays in the dealing of a community scheme. I mean, it goes without saying that he develops the property, so it is crucial. But let's just have a look at some introductory remarks. I think the first important thing that we should have a look at is who is the developer. And I mean, this is simply a definition that is contained in the legislation, so it's nothing brilliant, it's nothing amazing that I'm telling you guys here. All I can say, it's not a software developer, so it's not the people that deal with Facebook and those types of things. It is a person who's the registered owner of land on which is situated or to be erected a building or buildings in which the developer has divided or proposes to divide into 2 or more sections. So, I mean, it's a very complicated situation. Yeah, it's open for difficulty. How do we understand this? But it's simple. I mean, you've got a developer, he owns a piece of land and he wants to create a multi-unit dwelling, and then decides on a sectional title law. So what's the importance of this? And it's just as a matter of practicality. I mean, I'm not getting this in the act, but as I mentioned, the developer is the person that starts body corporates, and that's why they are important. Unfortunately, one cannot just go to Woolworths and purchase a unit. There is a bit of building and construction that needs to occur, and the developer is ultimately the vessel that facilitates this coming to be of a body corporate. So I've now said how who is a developer. Now let's just have a quick look at how a body corporate is established. And I mean, when one looks at the act, it's quite clear technically. Upon the registration of a unit into the name of a person other than the developer, then a body corporate is deemed to be established. But as I always say in sectional title law, it cannot be that easy. So just as a practical point of view, we need to understand what needs to happen before this so that the developer is in fact in a position to pass transfer to a person other than himself or herself. So firstly, they would have to register a sectional title plan, which must be approved by the Surveyor General. And also there must be an allocation, or they must allot a distinctive number to each unit. I mean, practically speaking, if we don't know on the sectional title plan which unit is which, I don't know how we will be in a position to actually define one's ownership over that property. So it's important that we must register the sectional title plan. Then when the sectional title plan is registered, the developer would then become the registered owner of each unit in the development. So that's the first phase. I mean, ultimately, if you are not the owner of something, you cannot pass transfer of that thing. So the developer would then, upon the registering of the sectional title plan, become the registered owner of each and every unit that is now allotted in the sectional title plan. What the developer would also have to do before now just passing transfer, if he's in a situation where he wants to register or reserve any real rights in terms of Section 25 of the Sectional Titles Act, this would also have to occur prior to the developer trying to establish this body corporate. I think this is a very hot topic. Linda and I have at great length discussed this, and I think it's something worth mentioning, and we are going to deal with the particulars of Section 25 a bit later in this presentation. Then also, they have to register real rights in respect of the exclusive use areas. And you can see there, I'm giving myself a few exceptions. We need to understand that there are some exceptions. So just for me to explain it, there's a few ways within which one can register real rights or exclusive use areas. One being that it is registered as a separate title and it's physically registered in the title deeds office. So I mean, it's a public record and it's registered in your name when one becomes the owner of the primary section. But what I can tell you where the exception lies is if there's a real right in terms of the or exclusive use area in terms of the management or conduct rules, then it's a different ballgame. Then it doesn't need to be registered because it's governed in terms of the rules. And then also lastly, and I mean, this is just a form of checks and balances to ensure that what is contained on the title deed is in fact what is going to happen and what is seen on the construction and on the development site, that the developer must actually compile a schedule which is certified by the conveyancer, setting out all servitudes and the conditions of title in respect of that particular thing. So again, this is just very rudimentary. I mean, as an owner, all of this would probably have to occur, or not probably, it would have to occur beforehand. Otherwise, the developer would not be in a position to, I see there's a bit of distortion. I'm not sure on whose side that is. Just be sure to mute if that might be the case. But to come back, thank you. But to come back to the situation, all of this would have to happen before the developer would be in a position to pass transfer to any other person and to establish this body corporate. So as I've mentioned, colleagues of mine has now coined the phrase demystifying. So let's try and demystify this mysterious inaugural or first general meeting. I mean, that's where the body corporate starts and where the management and the procedure where this control is now handed over from the developer to the management, the trustees then, and how it would then be handed over. So in terms of section 2.8, a developer must convene a meeting of the members of the body corporate not more than 60 days after the establishment of the body corporate. So just to backtrack again, establishment is linked with when a person other than the developer becomes the registered owner. So even if it's one, even if it's all, I mean, from a practical perspective, I know developers try and pre-sell all of the units and then pass transfer simultaneously. But I mean, there might be instances where this is done in a piecemeal fashion. And the moment where the first owner other than the developer is a registered owner, then the body corporate is established. So just as a point of interest and that we need to understand, I mean, there is now a sunset clause on when a developer must convene this meeting, which is 60 days. So what happens if the developer omits to hold an AGM? Simply, the body corporate will never be established. One can never live in a body corporate if that is the case. I just think before I over elaborate on this, it's just a joke. That is not the case. If there is an instance where the body corporate or the developer fails to have this inaugural annual general meeting within 60 days, then any other member of the body corporate is then entitled to call this meeting from their own accord. And when they call this meeting, then they can also hold the developer liable in respect of any costs associated with arranging, presiding, or whatever the case may be, costs associated with this meeting. So firstly, what is the notice requirements in respect of a annual general meeting? Nothing special, nothing new. It's the normal notice requirements for us to hold an annual general meeting. So we must send notice of this annual general meeting to all members, to all bondholders, to the managing agent. And then also in the instance where the developer has now reserved this real right in respect of section 25, then they must also provide notice. I mean, they're not going to give notice to themselves, but had it been a different person, then they would have been obliged to provide notice to themselves. Quorum requirements, again, exactly the same as in any other conventional AGM, where the body corporate is less than 4 members, then it is 2/3 of the participation quota, but not less than 2 naturally. I mean, a single person can never be a quorum in a sectional title environment. And then secondly, if it's more than 4 members, then it is the usual 1/3 of the participation quota is present at that meeting. So again, nothing special when it relates to that. I think the next slide is where we now get into the nitty-gritties about how one should differentiate this mysterious inaugural general meeting from any other annual general meeting that a body corporate may convene. So, as I said, more demystification. We're trying the whole purpose of this presentation is just to demystify everyone from what's going on. So, in terms of the Act and the regulations, the following would have to be decided on at the inaugural annual general meeting. Firstly, the members have to decide on the insurance coverage of the community scheme or the particular policy wording, whatever the case may be, but that we can take all of the steps necessary to ensure after this point. Secondly, the approval of the first budget. So the developer must propose a budget, and then it is again with or without limitation or changes in relation to that. So the approval of that budget. The third item on the agenda would be determining the amount of trustees and the appointment of individuals. So this is the appointment of the particular trustees and how many trustees will we be appointing. The fourth instance is placing restrictions upon these trustees. But I mean, when one looks at basically all of the first four, these are normally also things that one can see and encounter in a normal general meeting. I think where things become interesting, and you'll note the space that I've made for myself there, is the last three motions. And one will now see why I've actually made this differentiation and why we also need to understand the difference between these things, because there are a difference when one deals with the voting component for these last items. So the next thing that we'll decide on is a motion confirming that the developer has handed over all documents and paid residual amounts due to the body corporate. We are going to go into these documents that need to be handed over, as well as what the residual amounts are due to the body corporate by the developer. When one considers these voting issues, the developer is excluded from voting. So, but for the developer, the rest of the members are then, by way of a majority vote, would have to then decide whether this has in fact happened or not. The second thing would be ratifying agreements between the body corporate and the service providers. I mean, body corporates propose managing agents, body corporates propose service providers, body corporates, developers employ service providers. And now what would happen in this inaugural general meeting is the members would then decide whether or not they want to retain these services of these service providers. Again, as I mentioned, in this instance, the developer would again be excluded from participating in that particular vote. And then the last thing that is specific for this inaugural first general meeting is a motion approving the developer's evidence of revenue and expenditure. I never know why they want to use the word revenue and expenditure. I simplify it by saying evidence of income and expenditure, and as well as the financial records in respect thereof. So this is a very interesting one. I mean, should the developer now give some or other income and expenditure from the start of when he became owner of that vacant or stand or erf or plot? That's not the case here. The evidence of the income or expenditure, the evidence of...
Sorry about that. There we go. I've muted Andrew.
That's perfect. I almost thought that she was going to help you and just
I know. I
also
thought she
add
was
in.
commenting. It is Sandra that's normally commenting on these things. While we've got everybody interrupted, have you ever seen this? These financial residual amounts? I've never seen it, so I wouldn't even know what it looks like. When I normally go to a first general meeting, it's sort of like, "Hello, everybody. We're the managing agent. This is pretty much all we have for you to vote on. Goodbye."
Yeah, no, it's actually hectic, and I mean it might be an elephant in the room. I think in sectional title law, there's really a lot of elephants in the room. But to my mind, and all I want to explain is that what we need to understand in respect of where this revenue and expenditure may arise, we all need to understand that when a party takes occupation of a particular unit prior to the establishment of the body corporate, i.e. prior to that person becoming the registered owner, there is this component that relates to the occupational rental for that period, and the Sectional Title Schemes Management Act and the sectional title laws actually specifically place the entitlement on the body corporate to that occupational rental amounts. So for that period, where someone is just staying there, any entitlement of occupational rental or the payment, in fact, of occupational rental must then come back to the body corporate. But yeah, as Zerlinda said, these inaugural annual general meetings are quite cavalier, and it's basically what the developer decides. So it's very interesting to see how this will develop and to see if anyone at some point is willing to take this matter up for interpretation in the High Court, and see if we can't get some certainty as to what actually needs to happen here. So I've now mentioned that the developer must now hand over control to the community scheme. And as part of this function to hand over control, certain documents will in turn have to be handed over by the developer to the community scheme at this inaugural annual general meeting. So the first one is the approved sectional title plan. I mean, you can't keep it with the body corporate, or the community scheme is actually tasked with keeping a record of this. So the originals will then have to be handed over. The second thing, a clearance certificate from the municipality up until the establishment of the body corporate. So I mean, for all intents and purposes, prior to the body corporate being established, the developer would still be liable for the rates of the ERF or the plot as a whole. So a clearance certificate would have to be obtained in order to pass transfer to respective individual owners. And then when this clearance certificate is obtained, the clearance certificate must also be handed over at this inaugural annual general meeting. Then proof of income and expenditure, I've already touched on that, but this is the income and expenditure from this date of first occupation of a person until the date of establishment of a body corporate, i.e. that there is a person registered, or that a unit is registered into the name of a person other than the developer. Then we need to have the approved building plans. I mean, in this day and age, we are civilized, and as such, one cannot simply build. And I mean, I think there's a lot of conflicting views from some of the members of body corporates where they just decide to erect whatever they want. But in the conventional and in the norm, there should be approved building plans, and these approved building plans would then also have to be passed on to the community scheme. The next one is any encroachment permit or other document issued by the local municipality in relation to the improvements to the scheme. So whenever the municipality have these types of permits or documents that they convey to the developer, that should also be handed over to the community scheme. The next thing is plans showing the location of pipes, wires, cables, and ducts. And I mean, practically speaking, it would be nonsensical for us to have a stab in the dark and to hope whenever we now start digging or start banging up walls that we don't know where these types of things are, and that can create a huge problem for the community scheme if a water or power or whatever wire or pipe is cut into or is compromised. So it's very important for the developer to actually give these information to the community scheme, so that when further changes to any part of the property arises, that they are aware of where these pipes, wires, and cables and ducts are located within the community scheme. Then this number 7, this morning when I prepared, I was actually quite confused, and I like laughing at my own jokes, but you'll get the joke now. The names and addresses of all contractors, subcontractors, and any other person so employed by the developer. I assume that they add the requirement of an address, so that when we as the members are not happy with the standards that they built, that we can rock up at that address and start striking and fighting with them about why they didn't do what they should have done. But be that as it may, that's how the Act says, name and addresses, not contact details for some reason, but the physical address is what we want. Then this is again just a lot of verbose information, but this is how it is conveyed. All warranties, manuals, schematic drawings, operating instructions, service guides, documentations from manufacturers, and any other similar information in respect of the construction, installation, operation, maintenance, repair, and servicing of any common property or body corporate asset, and all of the occupation certificates in respect of the unit, and then any other guarantee or warranty that was provided by the developer by these individuals in not paragraph 4, I seem to have been misguided there, but in paragraph 7. So all of these contractors, subcontractors, and other persons, whenever they give a guarantee or a warranty, that must also be conveyed, or the documentary proof must be handed over to the body corporate. And I mean, simple example as to why we should do this. For example, operating instructions. We've got a lift. I mean, I don't particularly know how a lift works except for pressing the button and pressing the floor. So if there's any other like technical things that might be above our fireplace or that we should be expected of knowing, we need to be placed in a position so that we can actually understand all of these things and effectively manage, install, maintain. I mean, there's this whole double barrel of words that they use. It almost sounds like a 10-year maintenance plan. They're working the phrasing like a 10-year maintenance plan, but we need to have all of these information handed over. And then lastly, all of the records held by the developer in terms of prescribed management rule 27. I mean, this again, please don't ask me to elaborate on 27 because we will have a discussion about Poppy and Paya until the end of days. But prescribed management rule 27 simply says that a body corporate is obliged to keep a record of certain personal information of their trustees, tenants, and members. And these are things such as the full names, identity numbers, contact details, and the like of these individuals. So, I mean, Oliver is busy with his development and he's signing up all of these prospective purchasers who are so excited to form part of this development. He gets a record of these personal information. He's in fact obliged to now keep a record in accordance with prescribed management rule 27. And the moment that we have this inaugural annual general meeting, we must be placed in a position where we actually get these records from the developer so that we know who are the members and how we should deal with their personal information and what we should have about them. Then I think this is something that has resulted in a lot of headaches, late nights, fights, disparity, issues in a community scheme development, the nepotism and carte blanche that can be employed by a developer. I mean, I've now informed you all of the decisions that is to be made in this annual general meeting. And the one thing that I've alluded to, and I mean, that's because that's not a decision to be made at the inaugural annual general meeting, is the proposed rules by the developer. So from a sectional title perspective and from a matter of practicality, when one would sign an OTP to purchase into this new development, normally this would have to be accustomed or accompanied by the proposed or the management and conduct rules of this developer and of this scheme. But this is something that is not approved at the inaugural annual general meeting. So let's say, for instance, the developer, Mr. Dodgy, has slipped in various interesting rules. And I mean, I use it in enclosed brackets because it's not interesting. It's just simply selfish or whatever the case may be. And these rules are rules such as the developer does not need to pay levies. The developer is the chairperson of the board of trustees, or a representative of the developer must always be on the board of trustees, or any other unreasonable rule where the developer now tries and gets more rights than one should afford to a developer in this situation. So what now? We've got these rules. It is proposed. I mean, we've signed the OTP. So if you take the pragmatic approach as an attorney, everyone, and you might have heard of this, the caveat emptor principle or the buyer beware principle, where we say, I mean, when you signed that OTP, you knew this is the rules. So this is your problem, unfortunately. What now? And the short and the long answer in relation to any rules of a scheme is that the rules of the scheme cannot be discriminatory to any party or group of persons. So when one considers developer trying to now exclude himself from paying levies, I mean, in this example, the developer retains ownership of some of the units, and he now makes this rule to say that he does not need to pay levies in respect of these units, or he should pay R1 or whatever the case may be, but it's not aligned with all of the other members. This is not in line with the Sectional Title Schemes Management Act. We all know the general rule in relation to this is that your liability to contribute towards levy payments is in proportion with your participation quota, or if the scheme is really nice or not nice, depending on your circumstances, in equal value, which would mean then each and every member would contribute equally, regardless of their participation quota or regardless of the size of the unit. So this can simply not happen. And the unfortunate reality that we're faced with is we're sitting with these conduct and management rules, which has these rules in, and they are relying on this. But all I'm trying to say is that when this developer decides, or when the scheme decides to proceed with further legal action so that they can actually decipher, or that the courts can decipher what's going on, I've got my doubts as to whether those types of rules will in fact be firstly enforceable, and secondly, with all of the headaches that CSOS has also given us, I do not think CSOS will register these types of rules. But I mean, anything can slip in, as I've mentioned, but the crux of the matter is, if this rule is unfair or discriminatory in any way, and that can be conveyed to a court in a sensible fashion, so it's not your subjective view on the matter, it is as plain as daylight that this rule is discriminatory or unfair, then the courts or CSOS is not in a position to enforce these rules. So that's the short and the long answer. But I mean, we are dealing with developers who on a day-to-day basis develop schemes, and where they try and include all these types of shortcuts to benefit themselves, but ultimately the enforceability thereof is very questionable, and then I can't see any authority coming to a conclusion that these types of things are fine and enforceable, and that caveat emptor is actually is utilized in this particular instance. So yeah, I think that's just, again, a nice discussion point. We need to get the wheels turning. You need to start thinking about these types of things, because I mean, it's very important when one purchases into a community scheme that one familiarizes yourself with the rules and whether or not you're willing to abide by these rules. Otherwise, we are going down another rabbit hole where there's this whole disparity between the members and the community scheme and fines and all of those types of things, which is also, I don't think, great on any member's mental well-being, physical well-being, or financial well-being. So that's just something to consider when one tries to purchase into these community scheme developments. Then, as we all know the song, it's just a bit mixed up, but I don't want your love, honey, I want your money. So there is a lot of requirements that I've now mentioned where this body corporate, or where the developer has to comply with a lot of obligations. He has to give certain documents at the AGM. He has to transfer control. He has to transfer funds. There's all of these types of things. There's guarantees. I mean, from a building regulations perspective, the building regulator makes provision for warranties and guarantees that needs to be given in respect of the development. So let's say something happens and the developer or the scheme decides that the developer should be held liable. There is in fact provision that one can hold the developer liable for all of his acts or omissions, depending on the circumstances. So there is recourse if one feels dissatisfied with how this developer has conducted himself. One can in fact proceed to try and hold this person liable. One must just always be cognizant of the fact, and I mean, it's on the stark reality with these types of individuals that developers have access to a lot of funds. I mean, it's not cheap to develop. So when one wants to fight with a developer, or wants to take the necessary steps to bring them back to book, one must also just consider the viability of instituting litigation against the developer that has access to a lot of funds and that is willing to defend whatever that developer has now included, or to defend any act or omission. So we must just always pay close attention to this and to make sure that we pull the trigger at the right times, and not just as and when we want to try and enforce something against the developer. Then I've spoken about this elusive real right in terms of Section 25 of the Sectional Titles Act. It's such an interesting provision. I don't think a lot of individuals are aware of this real right. And I'm not trying to say the participants here, I'm trying to say you're the man on the street who's purchasing into this community scheme. I don't think a lot of them are aware of this provision, but I've quoted the whole thing. It's a whole verbal jargon, and you'll see the inclusive but not limited to, and all of the nice legal phrases that attorneys like to use. So let's cut right into this. So a developer may, subject to the provisions of section 4.2, in his or her application for the registration of a sectional title plan. And remember, just to backtrack in the past, before one is in a position to register a sectional title plan, this reservation must be noted. And this is how it is reinforced in section 25. So in his application, or in the application for the registration of a sectional plan, reserve in a condition imposed in terms of section 11.2 the right to erect, complete, or include from time to time, but within a period stipulated in such condition or such extended period as may be agreed upon, on a specified part of the common property, and to divide such building or buildings into a section or sections and common property, and to confer the right of exclusive use of parts of such common property upon the owners of one or more sections, or to delineate exclusive use areas on or in specific parts of the land and buildings in terms of section 5.3f, and to confer these rights of exclusive use over such areas upon the owner or owners of one or more sections. So I'm actually disappointed in that I can't have all of your facial expressions in front of me now, or a physical audience, because the first time when I was still a candidate attorney and I read this provision, after I read it, I was even more confused as to what this is now actually saying. And I think it's simple that we can actually unpack this in understandable and palatable terms. So just to give you an idea, you've got a development, there is a part of the common property. This would normally be a vacant part of the common property, so a garden or a piece of grass that has not been built on. And then what the developer would do is they would then reserve that particular common property to further build units onto the or into the body corporate. So they reserve this property for a specific period. Just to mention the specific period, normally this is 10 years, but then for this specific period, that they can in fact make the determination on a future date that we are now going to build 4 more units in our complex, and I'm going to use that part that I reserved to in fact build this. So just as a point of interest for all of the new purchases, and I mean, this is something we can advise these prospective purchasers on, that in the offer to purchase, the guiding document, the underlining causa, as all of our jurists would like to say, of your ownership and your entitlement to ownership of your individual
Did anyone else lose Dylan?
Yes, I was just wondering if it was my side only. But yeah.
Oh, there we go. There he is.
There he is.
welcome back. I just wanted to take a quick smoke break.
Okay, perfect.
but
100%.
I think let's abruptly continue with what's going on. So I just want to find my spot.
While you're looking, we do have a couple of questions that have come in. So we'll keep a couple of minutes at the end for that. And if anybody else wants to ask any questions, you're more than welcome to pop it in the chat. If we've got some time, we can take a couple of physical questions afterwards. Dylan, back to you.
Thank you. So again, just to recap on what I've said, I don't know when I was kicked. I mean, I was making this beautiful argument and conversation. So just to recap, we've got this patch of grass or whatever unbuilt part of the common property that this developer has now reserved. He's going to build a unit or 2 or 4 or 16 on that particular part of the common property. In the OTP, that's the first thing. When we advise any prospective purchasers, we must advise them that in order for a developer to actually enforce this right, he must include that in the offer to purchase. So he must notify us as prospective purchasers that, listen, yes, it's a patch of grass now, but at some point that might be 16 more units. And you must advise them to the extent to which you intend on developing this. So whether that's now 1 unit, 2 unit, and how that would then go about. When the developer makes this reservation as well, the developer is exclusively entitled to build in terms of this reservation. So if I've reserved this patch of grass for building 2 units, I cannot come the day when I want to start developing and now build 16 units. You must do it strictly in accordance with your reservation. This reservation would also then in turn be registered against the title deeds of all of the individual owners as a limitation or a restriction. I mean, ultimately, you are the owner of an undivided share in the common property, and at any moment when this undivided share in the common property might cease to exist, or that particular part of the common property might cease to exist, one has the right to know about this. So yeah, that's it in a nutshell. The practicalities in respect of this elusive real right that they reserved. They've now reserved that patch of grass. So, I mean, nothing in this world comes for free. So the costs of defraying the maintenance, repair, and replacement of that particular patch of grass or part of the common property that they are now registered, the developer is obliged to contribute and to expunge the costs associated with that. Similarly, and I mean, you can make the link between an exclusive use area where we would then now oblige this particular member or group of members to contribute towards their exclusive use of that particular part of the common property. Similarly, the developer would have to contribute towards the exclusive reservation in terms of this act in respect of the part of the common property that they may have reserved. I personally feel like I've said common property way too much here. So I think I'll, on the next slide, try and avoid to use the word common property. But from a practical perspective as well, this developer is not seen as a member per se of a body corporate because he's not the registered owner. I mean, when one considers the definitions of a member in the sectional title law, it clearly stipulates it's the register or the registered owner of a individual unit and or the name that is reflected on the deeds register for that particular unit. So that is the only people who are members. So this developer is not per se a member, but by virtue of this reservation, he is in turn entitled and obliged actually to contribute towards this maintenance, repair, and replacement of this particular part of the common property. I mean, a patch of grass might not necessarily have a lot of maintenance components, but there is this obligation to contribute for the time being and whilst that property is reserved for his exclusive future use, if I can call it that. So, another interesting topic, I mean, one, I can never stop talking about the Property Practitioners Act, and I always try and draw links between the Property Practitioners Act and one's conduct as a role player in the game. So from a developer's perspective, when one reads the Property Practitioners Act and specifically the definition of a property practitioner, it seems to suggest, and again, we're waiting the test of the courts to see how they actually now try and apportion the provisions of the Property Practitioners Act to this developer, but the definition of a property practitioner seems to suggest that an individual who sells units is seen, or who sells property is seen as a property practitioner. And I mean, a developer is a person of this nature. And I just wanted to touch on a few things where I feel like I see the quote there is nonsensical. That is for the previous slide, so just ignore that. But where I wanted to chat about it is that when I say that a developer is a property practitioner, I'm not trying to suggest that the property practitioner or the developer must get a fidelity fund certificate. And I mean, we've been through all of these requirements in relation to the Property Practitioners Act and how a property practitioner should conduct themselves. But some things that I have seen in particular importance, and I deal with this on the next slide, is the prohibition on the relationship between the property practitioner and the service provider, and also the conflict of interest. And I mean, in terms of the common law, the developer or any person who has a conflict of interest must declare this interest. But I think this is where the component of the developer actually ties nicely into the definition of a property practitioner, which means that the developer is not necessarily entitled to dictate who we should use. I mean, when one looks at the wording of the Property Practitioners Act, it says it's prohibited to oblige or encourage the use of a particular service provider. I mean, practically speaking, in most instances, in a body corporate context, it's difficult to say this. I mean, the developer has the obligation to appoint certain service providers before the body corporate is established. But ultimately, what I'm trying to say is that when this developer wants to propose any particular use of a particular service provider, I would think that this developer would have to at least convey their interest, whether that's a pecuniary interest or any other interest in this transaction happening. I mean, we all know in this industry there is a lot of backdoor dealings happening where the role players do not necessarily want to involve or inform the community scheme of these dealings. But this is where I draw this line between the Property Practitioners Act and the developer in the sense that one cannot simply say we must use A, B, and C service provider and not declare if there is an interest or trying to be biased towards that particular thing or encourage or oblige the use of that particular service provider. So as I said, I try to keep it short and sweet. I think, unfortunately, as a legal practitioner, one gets used to and ultimately, in a contrived form of Stockholm syndrome, start loving the sound of your own voice, and that's unfortunately definitely the case for me. So when we deal with questions, it's always the favorite part of the presentation for me. I mean, you guys are asking me the questions that I don't know the answer to, and I must either dazzle you with my brilliance or baffle you with something else, which I don't think is appropriate to be named in this presentation.
Well done, Dilen. We do have a couple of questions for you. Kaylee Dunn asked, if the developers install the central heating systems, the heat pumps for the complex, as well as a prepaid system for water, sewage, and electricity, whereby they, as the developer, retain the ownership of the heat pumps and the prepaid systems after registration, the on-charge of prepaid vouchers are at a slightly higher rate, but within the regulations, as though they are the vendor, the developer that is. The maintenance of the heat pumps are for their account, and they will be paying the city directly once the COCT account is in the body corporate's name. Is it legal for the developer to remain the owners of the heat pumps and also remain the owners of the prepaid system as though they are the vendors? And how would the auditors account for this if the city account has not been paid by the body corporate? I can't answer the auditing question because obviously we're not very financially skilled as attorneys. I'm not expecting you to know that. If you do, that'll be great. But do you have an answer to whether or not the developer can retain ownership of this body corporate's infrastructure and act as a vendor to the body corporate?
I mean, I think a good point of departure here would be that we would have to determine firstly whether there is this exclusive use area, if you can call it this. And I mean, this debate has now been going on with the solar components as well, where we actually have this roof that we declare as an exclusive use area. So is the developer firstly an owner of this exclusive use area, and have they now jumped through all of these hoops to reserve this particular portion into their names? And then secondly, what I would also add in this regard is where does the funds come from in relation to this? So to my mind, it wouldn't make sense that where a body corporate actually, or the developer, when they determine their purchase price, they include provision for installing all of this stuff And we as the owners actually now, when we purchase into this, we buy this and then they use it to their benefit. But it's a very interesting circumstance. I think to get a great answer on this, we'll have to have all of the components of this particular issue. I always say that legal advice on the fly is very dangerous. So I would think that if we would really want legal certainty on this point, we would have to look at all of the facts and then decide what the ultimate outcome is. But to my mind, it sounds dodgy. And I've always said legal, your rechtsgevoel, as we would say in the native language, or your legal view on certain things, or your legal gut feeling, if you call that, whenever logic or it doesn't make logical sense, then there's always, or most of the times, a snake in the grass. So it's very interesting, and I think we need to pursue this and find out what's going on with this.
Fantastic. I say the same thing, Dilen. Kaylee, perhaps you can contact Dilen via his website for that initial free consultation that he offers, and then take it from there. There's another question. Is there a requirement that the developer obtain a certificate from CSOS regarding the rules?
So when one considers the proposal, because it says that the developer must propose rules, but one can never read a particular provision or a particular section in isolation from all of the other sections in the Act. So to my mind, and I've made up my mind on this, and I feel like at some point we will get legal certainty, but when I read the provisions of Section 10, it seems that any other or any deviation from the prescribed management and conduct rules must be registered. It's I don't think there's any ambiguity in that provision. So to my mind, even the developer would have to comply with CSOS. But I mean, what I'm saying in this theoretical ideal world and what's happening in practice, unfortunately, is two different things.
Mm-hmm. Interestingly, and Nicole, Null, I don't know if you want to hop onto this with your experience of registering schemes and registering rules, but the CSOS actually has a bit of a shortened time period for the certificate of approval for new developments. In other words, yes. Nicole, if you want to hop onto that.
Oh, yes. So as unfortunately, it's not written down anywhere in like a solid document. But from correspondence that I've had with quality assurance officers at CSOS, they inform me that quality assurance of amended conduct rules or management rules, so basically any rules that are not Annexure 1 or Annexure 2 of the regulations of the SDSMA for new schemes. Again, this is what they promise, but of course it's not always delivered within that time period. They promise a 2-week turnaround time for new developments and 30 days for existing schemes.
Fantastic. If we have hit 11 o'clock, so if you do have to drop off, you're more than welcome to. We've just got 1 or 2 more questions, if you don't mind, Dilen. We've got a question about Section 3(1)(d). How does a body corporate determine or calculate the reasonable additional developer contributions? Who has the reserve Section 25 right?
Yeah, look, whenever I see reasonable in a piece of legislation, I start to shrug and become frustrated, because then it puts a lot of subjective elements into what can be seen as reasonable. But to my mind, one would have to consider the nature and exigency of the particular part of this common property. So if it's just a plane of grass that we need to maintain for this period, then I would say it would be the reasonable costs associated with that particular reservation. I mean, if it's a blade of grass, one would maintain it by cutting the grass. So then it would be a contribution in terms thereof. But I've seen individuals levying a levy amount which is equal to the normal levy amount or the conventional levy amount. So again, we don't have certainty as to what is reasonable, but to my mind, it will deal with the type of the common property that is reserved and how much effort and how much money would have to be put into that particular part of the common property by the body corporate to make sure that it's adequately maintained and repaired and replaced, or whatever the case may be.
Fantastic. And then the last question that we have on the chat function is, does the developer appoint the managing agent before the inaugural general meeting?
So to my mind, they would have to, yes, because I mean, in practice, when one gets to the inaugural annual general meeting, the developer is there with his whole team, inclusive of the managing agent. But I mean, from a body corporate's perspective, the decision can still be made after the fact, whether or not we want to retain this managing agent after the inaugural annual general meeting.
I know that we do have some managing agents online, so it would be interesting to hear from them as to their relationship with the developer. In my experience, when I was a managing agent, we very infrequently received a contract before the inaugural general meeting. We had to do a whole bunch of work on spec with the promise that we would become the managing agent, but of course it would be up to the members at the inaugural general meeting. And of course, then if the relationship between the members or the new purchasers and the developer went south, that unfortunately impacted on the managing agent as well, because you were considered to be the developer's contractor and the members wanted to get rid of everybody that the developer had any dealings with. So it's a very difficult situation to be in. I'm going to stop sharing of your screen, but just a note that the PowerPoint presentation is going to be available online. And if there are any questions from the floor, we can spend a couple of minutes answering those. And if there isn't, we'd just like to remind you that the recording as well as the slides will be made available on our website. You'll find the link on social media as well as in our newsletter. We have shared information on our neighborhood, our blog posts, how to join our newsletter, and of course, very importantly, the link to Dilen's website at DTB Attorneys de Tooiburger. Dilen, thank you so much for your time today. I don't know if anybody's got any questions or any comments that they'd like to make. We had a couple of very good thank yous and compliments, and noting that it was very informative and insightful and interesting. So thank you very much, Dilen, for that. You put in a heck of a lot of work into the preparation for this, and I know that we've had a nice discussion about it before as well. Are there any questions or comments from the floor? You're welcome to unmute yourself or stick up your hand or put your camera on.
I always get concerned when there's no questions, because then I wonder, was it me that was so good that no one has any confusion, or did I confuse them to such an extent that they're not willing to engage with me? So hopefully it's the former.
It's definitely for me. You gave them a lot of information, but if I know the audience quite well, they'll pop you an email afterwards as well. So yeah, Lee just said questions may still come afterwards, definitely. So ladies and gents, on that note, thank you so much for your time. Dilen, thank you again for your time, and please do keep us posted as to the outcome of that very interesting case that you're working on. And I know that we had Stratafin online as well, so thank you very much for their time as well. You have all the dates and times of all the other events that we're going to be involved in. First up, the NAMA breakfast tomorrow. It'll be nice to see physically some of our friendly faces again, so looking forward to that. And on that note, thank you very much, everybody. Have a lovely day further, and tomorrow's Friday, so have a good weekend, a long weekend we're having. Our offices are going to be closed on Monday and Tuesday, so if you'd like to get hold of us again, you're welcome to on Wednesday. So ladies and gents, have a good one, keep well, and thank you so much for joining us once again.
Thank you, Zia.
Bye-bye.